Hello, everyone. Welcome to our webinar today. This is the Mortgage Quality and Compliance webinar, and we're so excited to have you. First, we're going to start off with some information from Monica. If we could pop forward a slide.
Perfect. Well, hi, thanks everyone, and welcome to yet another wonderful webinar by the California Mortgage Bankers. I'm Monica McCarthy with Crosscheck Compliance. We are a nationwide regulatory consulting firm and a proud and active member of the CMBA. We have a qualified team of professionals who have broad and deep mortgage expertise. We're currently busy helping many of you of our clients with fair lending, both program reviews and data analytics. We're also seeing more servicing audits among other required audits. We've been getting more and more requests to do pricing exception and ATR reviews. The regulators are getting focused on that, as you may know. And we also now perform the file reviews for securitizations with an emphasis on our non-QM expertise. We work with a lot of you directly, the mortgage lenders, but we also partner with our law firm friends, and we perform some of those engagements under attorney-client privilege as requested. And as you all know, I enjoy networking in the industry. Loved seeing many of you at the MBA conference just now in Miami. So don't hesitate to reach out to me directly if you have questions or want to talk about the industry. So thanks, Paula.
Thank you so much, Monica. Yeah, I was going to mention Monica's a great networker. She's definitely somebody you want to connect with, and she's always very happy to help when you have random questions or needed any advice or recommendations. So highly recommend it. Plus pricing exceptions, yes, very hot topic. Something we talked about a few webinars ago. Very important to be keeping your eye on that. So thank you so much. So for today, we are jumping right into the webinar, right into the good content, because social media is a blast to discuss.
Definitely.
And we have some wonderful speakers today. So we have Melissa Thomas. She is the VP and Head of Compliance at Active Comply, which is a cloud-based software that allows lenders to monitor social media for compliance and brand protection. So it's also important for our marketing departments. So that's something you can use to help convince everyone that you need your social monitoring. It's also about marketing and protecting your brand. So Melissa works actively with lender partners to develop their policies and procedures to fit their needs. And she spoke in December at our last California MBA conference. And so as soon as we talked about social media, I said, we need to have Melissa. Yay, so I'm so glad you're here. Now we also have Bella Guerrero. She's the VP of Compliance and Managing Counsel at Guild Mortgage. She's a frequent speaker at webinars and conferences, and she came very highly recommended, so I'm very excited. No pressure, Bella.
As long as I have Melissa here with me, I think we're in a good position.
I felt the opposite way, so I can't wait to see how this goes.
See, it's going to be a good conversation.
It's gonna be good. It's gonna be good.
Both of these ladies were just at the MBA Legal Issues and Regulatory Conference in Miami, and they mentioned before the call that they learned some wonderful items from that conference to share today, plus obviously their own expertise. So thank you so much, ladies, for being here, and please take it away.
Sure thing. Thanks for having us, everybody. Bella and I definitely were at that conference earlier this week and got quite a few nuggets of information that we're going to do our best to interlace into the current presentation that you see today. Bella, maybe you can start us off by talking about social media advertising. We're going to be jumping into new mediums, new threats, talking about enforcement priorities, of course, the public risk that is the Townstone case. We got a couple of nuggets of information around that. Specifically at this conference, talking about fake reviews and the gag clause with the CFPB. We can't go through social media without talking about fair lending, examinations or targeted ads. And then we're going to be finishing off with minority market review, as well as a discussion about LEP borrowers. So we'll go ahead and jump right into understanding social media advertising. Bella, take it away.
Awesome. Thanks, Melissa. And I'm really excited to join you today and be presenting on this topic. It's just continues to be a relevant topic, especially with the expansion of social media platforms, which I know you'll cover in a little bit. I guess just going back to basics, anything that can be deemed an advertisement and is published on social media is subject to the same federal and state requirements as advertisements delivered through other means such as mailers and emails. So under federal law, an advertisement is broadly defined as a commercial message provided in any medium that promotes directly or indirectly a credit transaction. There are certain disclosure requirements that need to be presented on an advertisement to comply with federal law, and state laws may add their own additional state requirements. One thing I wanted to mention, which I found interesting over the years, is with respect to state law, I have seen many states update their regulatory requirements to specifically call out electronic media. Some go as specific as social media, and just bringing awareness to that. However, I do think the absence of calling out social media in a statute does not mean that that method is not a platform that's viewed by regulators as a form of advertising.
Right.
So why is social media advertising so important? I've read many studies throughout several years, and I'm sure you have too, Melissa, where they talk about the impact of social media advertising and marketing on one individual's business. And without a doubt, I think every study always ends up with the same finding, which is that using social media marketing helps individuals outperform their peers. So there is a true return on investment. And the reason why I think part of it is it allows someone to reach an audience that they wouldn't otherwise. It allows you to have this far reach. It's accessible to everyone. And I think it allows someone to humanize themselves, to add their personality to the mix while also advertising services and products that they offer. And that's so hard to do with mailers and other things of that nature.
Not that they're not useful still,
That's
you know,
true.
but
They are very useful, but don't have the same impact. Still have a great impact, but not necessarily the same impact as social media marketing. And I think it's those same reasons that I mentioned, the far reach, the easy accessibility, that make social media marketing what I like to call low-hanging fruit for examiners. I don't know if you would agree with that, Melissa.
they're picking it right off the vine, I tell you, you know.
Well, and that's exactly it. They're doing it all on their own. They don't need us to provide them with the collateral, right? They can just go online, they can Google the company name, they can Google the loan officer's name and find all these social media platforms that exist today that market this individual and the company. And they're able to quickly identify patterns of compliance and non-compliance on these individual sites and essentially make an assumption about how your company is able to manage social media risk. So I thought it'd be helpful to just mention a couple of best practices in terms of just general social media monitoring or compliance management around electronic platforms that a lender can incorporate into their process to ensure that they have a strong system. So I think there's 4 essentials. One is policies and procedures. And I think what's important about policies and procedures is identifying not only who can advertise in social media on behalf of the business, but what can they advertise on social media on behalf of the business. So for example, how does your company feel about political speech? Is that permissible if it's on a company sponsored social media platform or web page? And then training. You can have generic training that speaks to advertisement standards, but I think it's important to also include that these electronic media and platforms are subject to the same requirements. I still every once in a while do hear about sales individuals, loan officers that just do not view their Facebook page or their Instagram as being a marketing platform. And I think that's still a mindset that we need to shift and make them recognize that this is a platform for advertising, and that's how examiners view it.
It's very optimistic if they're taking that stance. The regulator feels differently for sure.
Yeah, very true. Onboarding. It's important to make sure you have a process to identify the work-related social media pages when onboarding a new employee. And one thing that I found that's helpful is also having that process to identify employees who are switching roles. So for example, loan processors don't typically advertise, but if a loan processor is moving to a sales role and they intend to advertise, are you also capturing them in that process? Sometimes that gets missed for the transition of a role. And lastly, monitoring. So ensuring you have a way to monitor employees' posts on a go-forward basis. And I think for both monitoring and onboarding, depending on the size of the company, you could look to leverage technology to make it a more efficient and streamlined process. And I'll just mention vendors like Active Comply, as well as other companies. They exist to make our jobs in the compliance department easier. So we can be, what I like to say is more proactive instead of reactive, or at minimum, identify things on a more real-time basis, as opposed to having staff review posts after the fact, where it could be a week later that you identify a potential issue.
Right, and there's so many tendrils out there of social media. How could you possibly have a handle on it? If you're a larger institution and each loan officer has 4 social media accounts and they post on those twice weekly, that's a lot of content for you to try and sift through. And inevitably, the one item that you hadn't taken a look at is the one that the regulator finds first thing, because that's just how it goes for us, isn't that right, Bella? Some key information to add to that is keep in mind that there are different state-by-state requirements, like Bella mentioned. For example, if you have Texas licensees, you're expected to have the Texas Consumer Complaint Disclosure located on your social media accounts for those licensees. For those of you who have seen it, it is a big block of text. So how do you possibly start to put that on limited bio sections for things like Twitter and Instagram and the like? So having those conversations that not all social media is built the same. How do we make stronger arguments for compliance when we're having those conversations with our regulators? How do we use these mediums while making sure that consumers are protected, right? And also keeping in mind that a lot of social media platforms, but not all, make a distinction between business and personal, right? And that comes with some different fields altogether that can make a stronger argument for compliance. Often they give you and your LO the opportunity to look at active ROI metrics just the same. So if you have a business, Facebook, you can go through the Meta Business Suite to keep track of impressions, what consumers are converting into leads and things like that. So it is valuable for loan officers to make that business switch, just the same as it is for the compliance team to sleep well at night, right?
Completely agree. One thing I wanted to mention quickly, Melissa.
Oh, sure.
Related to the state requirements, you're absolutely right. Some states have these very long disclosures that are required. What I've noticed, from a lender's point of view, is states are more aware now of the constraints that we have on the social media side, and they're willing to work with us. So they understand you may not be able to fit that whole disclosure on a social media profile. And they are amendable and flexible when it comes to how do you disclose that? Do you have a link where it's separately posted on a web page? As long as I think it's visible and easily accessible, they're willing to work with you and find that you're in compliance with the intent of the law.
What an excellent point, that half the battle might be educating even your regulator on this really new medium. There might be the addition of new medium, new threats on our next slide, like TikTok. They don't know how it functions per se. I had to learn TikTok myself just to keep up with the market, but half of it is educating them. We did see quite a few regulators reach out to lenders about the Facebook business change to the new pages experience. And for those who are unfamiliar, Facebook has business pages, and they had a substantial change in the formatting of those pages, where information was located, what fields existed, which ones disappeared with that new change. And unfortunately, they weren't telling people when that switch was occurring. So a lot of lenders' LOs were switched to the new page, looks nice and shiny and new, but it was removing the impressum section directly with all of their licensing information. So people were getting cited in those examinations, and it took some finagling with regulators to get an understanding of this wasn't our fault, it was out of our control, it's a medium that we don't have complete control over. And you're right, Bella, they were totally understanding and were able to make some amendments. So always keep that in mind, communicate with your regulators. They know that they're not experts on this either. And that takes us into the next slide, which is new mediums, new threats. There are some shiny new tools out there in the industry that are noteworthy that your LOs may be starting to dabble in, or maybe you as an institution are taking a really hard look on how you can start to incorporate them into your process. One key one is TikTok that we mentioned earlier. We're seeing that a lot of loan officers are starting to get their toes wet with TikTok. Some lenders are just outlawing the practice altogether. They don't feel comfortable with it. They don't understand it yet. Some LOs are doing it all on their lonesome. They're doing the beta testing for you, whether you know it or not, right? That's always fun to find. I will say that TikTok is a really unique platform for those who are unfamiliar. It's short stint videos, so it's really digestible content for a consumer to see. Do I want to understand how mortgages work? I can watch this 3-minute TikTok. Do you think that all of the required information makes it in there to get a really round picture of how mortgages work or how a loan product functions? Probably not. So there's things to think about with TikTok, the limitations and how you're talking about product offerings. There's a really large following for TikTok. So we've seen a lot of loan officers who have maybe 300, 400 followers on their Facebook business page have 6-figure followings on TikTok. So it's a lot more addicting with the algorithm. There's a lot more exposure, which is great from a sales perspective. Is it also compliant, that same exposure? So that's something to keep in mind. Also keep in mind that TikTok is a limited bio social media profile. So you only get about 150 characters or so to get all that licensing in there. As Bella mentioned, making use of links where you can is going to be pivotal for compliance. And that's where Linktree might also come into play. A lot of loan officers are utilizing Linktree. For those who are unfamiliar, Linktree is a singular link that takes the consumer to a page of links where you can make a stronger argument for compliance. You might have your privacy policy link in there, your legal licensing link, a social media disclosure. So it sounds really great up front. A lot of loan officers control these link trees all on their own, which means there's some additional links that somehow make it in there from time to time, like my credit repair podcast, or a link to my favorite realtor's website, right? So that now raises new compliance concerns. So being aware of who's using Linktree, how it's controlled, what you allow on those link trees, and certainly addressing it from a policy standpoint will be key. Another key social media site that's on the rise for our industry is Alignable. For those who are unfamiliar, I'm going to be saying that a lot just to make sure everybody's up to speed. All different levels of technology insight probably on this call. Alignable is a small business referral website, which really makes me itchy as a compliance person, right, Bella? I'm thinking RESPA Section 8 concerns, kickbacks, things like that. It comes in as the name of the small business, which would be ABC Mortgage. And then on the right-hand side, there's an Our Team section describing who might have made it. The really concerning thing about Alignable is a field that you don't see on other social media platforms called Our Ideal Customer. It is a free-form text box where we have seen instances of demographic information. I like helping single moms find the right loan product for them. What about single dads, right? Those are protected classes. Sounds really topical. Could be a really big fair lending issue. Or I work in these parts of town. I serve these zip codes. You've got redlining issues. Down below, recommendations are being shared back and forth with realtor partners and other settlement service providers. Thanks for your continued business. Can't wait to see what the rest of the year looks like, sending some gift cards your way. These are all things that we've seen at Active Comply. So it also goes to showcase that not all social media is built the same for our industry, right? Some has more inherent risk than others. It's certainly worth addressing again in your policy. Something that we've recently seen a spike in outside of TikTok, Linktree, Alignable is the addition of Redfin. So for those who may not know, Redfin is now launching a Zillow-like page where you can see a loan officer have reviews, and it links to specific loans that have closed. So it'll link to specific houses and things like that. So it goes kind of a step further than the typical review in Zillow. So that's something to keep an eye on if your loan officer is making Redfin pages and how that might have some compliance concerns. And then we're also seeing a new trend in Audible for your loan officer, where this is the new housing site for those free credit repair podcasts and things like that. So being aware of all the different sites that podcasts could be hosted and that Audible is on the rise, as well as lead generation. At this conference in particular in Miami, there was a strong discussion about lead generation websites. We want to not always have to say no, right? We want to get to a yes where we can from a compliance department perspective, but knowing what questions to ask and making sure that if you have a lead generation site brought to your attention as something that your loan officer wants to use, we would certainly encourage you to go through what a consumer would go through. You know, got to eat the dog food before you allow any use of it, and see if there are any compliance concerns as you go down that path. Is there a warm handoff from the lead generation website? Is that going to be a RESPA concern, right? They suddenly become a settlement service provider. Are they licensed to do so? Many states require licensure for these types of things. So certainly keeping that in mind.
All great points, Melissa. And you always tell me about these platforms that I didn't even think of, like Audible. Now I'm making a note of that, and we'll take that back.
Right to the side, pause this whole webinar to go look at your own loan officers. Sometimes it's like that, right? So let's go ahead and take a look at our next item. If my screen is frozen, please. All right, we made it. That was a close one. We'll be jumping into enforcement priorities. So for those of you who had the chance to sit in on Active Compliance and Coffee, which is always great fun, some of this is going to be old news for you. But for those who hadn't had a chance to join us for that, the DOJ back in October with Merrick Garland had announced a joint initiative to combat modern day redlining. So this is going to be a joint initiative with the DOJ, the OCC, the CFPB, where they are hoping to join forces with the quote unquote department's most aggressive and coordinated enforcement effort to address this modern day redlining. And what's really notable about that announcement is that they're going to spare no resource for vigorous enforcement. They're making that really clear in the announcement. They're also showcasing that modern day redlining is certainly on their radar, but they don't go so far as to define what modern day redlining is. So there are a couple of different ways that we could address modern day redlining. So one of the top ones is certainly targeted ads, web-based and social media. There's a lot of conversations about those AI pricing engine black boxes. I think the CFPB right before this call made an announcement about higher regulation of those. That was a big topic of discussion at the conference as well. Making sure that with how you're getting those consumer reviews and talking to them is going to be key. We'll be talking about that a little bit later on with the gag clauses and things like that. So modern day redlining is quite a large umbrella of lead generation and pricing and targeted ads using data to find those consumers and getting them the products they need. What data are you using? Is it a proxy for a protected class? Things like that. So these are the conversations you have to be having with all parts of your organization, not just the marketing department, but also, your hiring, your IT department and things of that nature, most assuredly. We're gonna try this again. All right, it worked this time. So Bella, maybe you can speak to us about the highly anticipated Townstone case. I know we heard a lot about that at the conference this past week.
Yeah, it's a very interesting case. So I'll start with some background. So in summer of 2020, CFPB filed a complaint against Townstone Financial, and they alleged violations under ECOA, CFPA, and FDCPA, I believe. The complaint alleged that Townstone engaged in unlawful discrimination, including redlining and acts or practices that would discourage prospective applicants on the basis of race from applying for credit in the Chicago MSA. So what's interesting is that CFPB points to Townstone Financial's marketing as evidence that they allegedly violated ECOA. The complaint states that Townstone's business model had been to market and to draw mortgage loan applicants primarily through radio advertising. And starting at least as early as 2014, Townstone had been marketing through this podcast that they had, the Townstone Financial Show. And it was a podcast and a radio show, and both of those were streamed on Facebook Live, and then also advertise on a couple of social media platforms, including Facebook, Twitter, and I believe LinkedIn. The complaint also alleges that Townstone had regularly included statements that would discourage African American applicants from applying for mortgage loans or making or pursuing an application. In the complaint, CFPB also added that Townstone Financial did not target any marketing towards African American consumers. Do you want to go to the next slide, Melissa?
Yeah, absolutely.
So on this slide, we have some of the information that's in the complaint that CFPB had filed against Townstone. So they had alleged that 90% of applications were generated through the radio advertising, and that out of 2,700 applications from 2014 to 2017, 37 applications, which is 1.4%, came from African Americans. So you're probably thinking like, wow, that's a big disparity. Especially when you also look at their comment about the peer review, which states that according to their peer analysis, other lenders in the area had 9.8% of applications come from African Americans. And to an earlier point Melissa made, they not only looked at the peer analysis and the marketing, but they also looked at the employees and what the makeup of the employees were. And they had noted that, you know, it's a small shop. They had 17 loan officers during the time period, and not a single one was African American. What I think is interesting was Townstone's response to the complaint. So their take on it was that the show is both a means of marketing and political, and the hosts have different political views. And they further state that CFPB was very selective. So they just took a few political statements out of hundreds of hours of radio time, because again, the show, just like the CFPB said, has been going on since 2014, and they use certain selections to paint a picture. And I think the takeaway with regards to marketing is that general public marketing, so marketing that's really not geared towards a specific person, but just geared towards the general public. So things like social media, blogs, radio shows, I think they're all fair game when it comes to reviewing where there's a potential, if there's a potential ECOA violation. And the theory under which the CFPB is doing this is the discouragement of having minorities apply with a certain institution. And there's no need to actually point to an applicant, because there was no applicant in this case. It was just the theory of, well, discouraging potential applicants that did not show up as a result of the statements made during the show. And, you know, we see this again in Trustmark National Bank settlement, where marketing strategies, they're a factor in that settlement. And the settlement states that the bank did not monitor or document where loan officers developed referral sources or distributed marketing, but they did note that the bank's advertisements did not regularly appear in Black or Hispanic targeted media. So the absence of being present in that community was something that counted against the company. And I think that's what we're seeing in Townstone as well. And again, there's references to marketing collateral that's just generally out in the public, but not necessarily geared towards a specific person. And in Trustmark, same thing, where there was no mention of an actual applicant, but the discouragement of the potential of applicants to come to that bank.
Yeah, there's just so much to unpack in this case. And for anybody who's listening on the call today, I would certainly encourage you to go read that complaint, maybe with a glass of wine. There is a lot in that complaint to read through. Interestingly, there is some cherry picking of facts, right? So there's a peer analysis review for African American borrowers. Some of the potentially derogatory comments made on that podcast/radio show were about female borrowers, but there's not a direct correlation to peer analysis for that. Interestingly, it was quite the span of time where certain statements were taken and reviewed. I know that some of the representation for Townstone has argued, you know, ECOA doesn't have that type of reach. You know, it doesn't speak to advertising in any way, but we know from examination manuals that advertising is a part of ECOA review for examiners, interestingly. So with that in mind, we know that our good friends at Crosscheck have also done a new peer-to-peer analysis, it seems, where it's been alleged that the way that the CFPB did it was a little bit more apples to oranges, and we want to get a better, more rounded view based on actual peers who might be not credit unions or depositories, but other mortgage lenders in the area for more apples to apples analysis. So it'll be interesting to do a comparison of that data. And then keeping in mind that we're all watching this to see what's going to happen at the end. Is this going to kind of define what a peer is in that peer group analysis and how that might make a big difference for other lenders in the future? Lots to unpack, lots to keep an eye on for sure.
Yeah, and that's a great point about peers. I think it's important to remember, so the CFPB, I don't recall, I don't believe give any indication of who the peers are, but peers can change for a lender from one MSA to the next, and it doesn't always have to be the same group of peers if you can justify, you know, based on your business model in this segment, that these should be your peers. So I think that's an important fact.
Yeah, and is this smaller lender being used as an example to set precedent before the going after of some larger institutions? It will be interesting to see how this turns out at the end. So we're all keeping a close eye on it for updates for sure. Next, we're going to move into CFPB policy statement on consumer reviews. Bella, you have some background on this in particular.
Yeah, this was an interesting one. So in March 2022, CFPB issued a policy statement on contractual gag clauses and fake reviews. And they had indicated that financial companies could face consequences for illegally manipulating or suppressing customer reviews. And the policy statement focused on 3 different areas that I'll cover quickly. The first being the contractual gag clauses, and that is an attempt to silence a consumer from posting their review online or other means. And the example that they gave was by including clauses in contracts, so form contracts that don't allow a consumer to post their honest review. This would be deemed an unfair or deceptive practice. They also spoke about fake reviews, which is posting online reviews that are not legitimate. So for example, having a third party who has no connection with the services or products post reviews in a way that makes them appear as if they're completely independent from the company, so a hired third party, and makes it appear as if they actually use the products or services, or even taking it a step further, having folks within the company pretend to be those independent individuals and post reviews on behalf of the company to help improve the company's ratings. So practices like this would constitute a deceptive practice. And the last one was review suppression or manipulation, which is choosing to only display a certain subset of reviews, likely positive reviews and positive
Weirdly.
I know.
Yeah.
No one has chosen to only post negative reviews yet. And suppressing those negative or even neutral reviews. So really bolstering all the, and I love your imagery here, the 4 or 5-star reviews. And the CFPB states that consumers cannot easily shop and compare products and services when there's a limit to the reviews that are posted, and I think their exact language was it tricks or confuses the consumer. And I think what's important here is for everyone to consider the vendors that they work with and how they're utilizing the reviews received from the vendors. Many companies do work with a lender to solicit and collect that feedback, but it's really up to the company to decide what to do with those reviews and to decide which ones appear online and sometimes get pushed automatically to social media as well. So I think companies need to make sure and review whether they have controls in place to determine if reviews are real, and look at their process in terms of potentially limiting reviews or painting an inaccurate picture of customer satisfaction. So another example is, Or you as a lender portraying that you are a 5-star lender. Well, is that really accurate? Is that based on all the feedback that's received, or is that limited to reviews that are 3 stars and above and you average out to 5 stars? I would say you should also look at your customer facing documents or messages that solicit a review or reference a review, and see if they put any pressure to either post a certain type of review or potentially remove negative reviews in terms of, you know, the conversation that you're having, potentially a complaint, that if it's resolved to someone's satisfaction, are you pressuring them to then remove any negative feedback that has been posted about the company? I think some other best practices. I'm sorry, did you want to add anything, Melissa?
I was just saying, right. I hear you, girl. I hear you loud and clear.
Some other best practices to keep in mind is reviewing current contract provisions to ensure that all unenforceable provisions are in compliance with consumer protection laws. What I've always found interesting about the CFPB that I think is noteworthy is that examiners have found unenforceable contract provisions to be deceptive, regardless of whether those provisions are actually enforced. So just having them in your contract puts you in, you know, it kind of raises some red flags for the examiner. So you don't want to land there. And then companies may want to also look at their approach to their complaints in general. And I think I already mentioned this. How do you, when something is resolved, do you solicit a positive review? And is that solicitation, is it is it putting pressure on the consumer? I think that's the word I'm looking for. And in the reverse of that, are you asking them to remove a negative review, or are you asking them to follow up with their general experience? Because I do think there's a way to handle that, but you just don't want your messaging to come across as if you're putting undue pressure on someone to do something in order to get a certain result.
Right. I think that the spirit behind this is certainly to know that the consumer has power. They can make these statements, they can stand behind them. And if you resolve it, that's awesome. If they choose to update or remove it, that should be at the consumer's discretion and not at the behest of the lender. Right. So keeping that in mind when you're making these policy decisions. You brought up a really good point of, if you're utilizing a vendor to manage your review process, right, the reviews that come in for consumers when a loan closes, inevitably, quite a few of them have some standard settings that are put into place where if it's a 5-star review, automatically post it to things like Facebook. So if you're a consumer and you are looking through a loan officer's Facebook page, you're only going to see those 5-star reviews, and maybe those 3-star, 2-star reviews are available on the review site, but they're not publicly posted in the medium that the consumer is seeing. So is that in some way falling under this guidance? I would say so. Are you being honest about what consumers truly feel about that particular loan officer? And that you might be doing without thinking about it, right? That's the default setting, I think. So taking a look at your vendors to get a really good idea of what's actually happening with reviews and what you could defend to your regulator if they were in the room will be key for this particular item for sure.
That's a great point, Melissa.
We're trying. We're getting as much in here as we possibly can. And that, keeping consumers in mind and staying with this theme, we'll talk about, fair lending examinations. We did touch on this earlier with Townstone and things like that. But Bella, maybe you can give us some more insight from the lender perspective for fair lending right now.
Sure. So what we can deduce from recent complaints filed from the CFPB as well as the settlement I mentioned is that when it relates to fair lending exams, to COA violations, is that marketing and fair lending, I think it's safe to say they go hand in hand. Or at minimum, I would say that the CFPB, without a doubt, is reviewing your marketing strategies as one of the factors to determine whether a company has discouraged applicants from applying for credit with an institution. There are resources available, such as the CFPB examination book, which you can just go to see how they review for these items. But some takeaways from recent settlements that the trust mark in particular that I found interesting was some of the factors they're looking at, which is one, branch locations and loan officer locations. So they look to see where's the physical location and of all your branches in a certain MSA, and are those primarily located in majority white areas. This one gives me a little bit of heartburn because banks are more likely to have branch locations. I think we live in a different world today, even pre-COVID. Mortgage lenders, independent mortgage lenders, many were not very branch focused and location focused, that we can communicate with consumers in a different way. And in this post-COVID world, I think that's come to light even more so, where we're seeing states now have flexibility in terms of licensing.
Right.
And so it's hard when the CFPB is looking at your locations, but you know what, you may have not opened the new office since before COVID, but that doesn't mean you're not reaching those other areas. So areas that aren't majority white areas. So I think documenting and understanding how you're reaching those areas is going to be even more important, because they will look to your branch locations. I think some other areas they look to is your staff, the staff working within those the MSAs, the loan officers, the processors, and has the company made attempts to diversify its personnel if there is no diversity within the staff. There's also marketing, which we've talked at great length. So again, they're not just, they're going to start by asking you if you have addresses where you sent marketing, and they'll look to see where are those locations within the MSA? What are your location of referral sources? But if you don't have those addresses, if you don't maintain them, or if you don't do targeted specific marketing, their review doesn't stop. They'll look more broadly at what areas are you covering with your marketing, with your social media. And I think a good one is publications. Some folks will say, well, it's not directed at anyone in particular, but we publish in these magazines. Well, they'll look to see what areas receive that publication, and that will speak to your reach within the MSA. And in addition to the actual reach of the marketing, they look at the representation in the marketing to determine who's your target audience. And I think this is an important one for businesses to really look at their marketing to see if it reflects, the society we live in, and whether it reflects the diversity that we experience regularly. And I think diverse marketing will actually allow a business to appeal to a broader audience, and it should be incorporated in your process, some type of review around diversity and imagery in the marketing department if it isn't already. And lastly is the HMDA data peer analysis, where CFPB will identify peers within an MSA and see, yes, right. Exactly, yeah. Peers, to see how you compare against your peers. And again, going back to the point Melissa made and I said earlier, you may not agree on who the peers are, and you need to do your own analysis to identify the peers and see how you measure up against who you identify as the peers. And I would say have a good argument as to why those are your peers, and why the results are coming out perhaps a little differently than what the CFPB is trying to portray in the context of this examination.
Right. Some things to keep in mind is, hopefully we're on the downside of the whole COVID wave. It's been a couple of years now. As you're starting to return as an institution back into office, or if you're looking at hybrid, if you're looking at desk rentals, to always view some of those decisions through the fair lending lens, right? What does this equate for us from an examination standpoint? If I had to have that conversation with my regulator in the room, could I do so? Or does it pass the smell test at the end of the day? So keeping that in mind and knowing that peers are certainly ever evolving, doing your own analysis might prove really useful later on if you're ever in a situation like Townstone where you might have to defend yourself, and hiring excellent firms, potentially like Crosscheck, to do that for you, to work with you. Having vendors that can give you really strong explanations behind it will be key for fair lending examinations going forward. And keeping in mind that demographic representation within marketing images is certainly going to be pivotal. Who are the models being represented within those marketing images? But there are additional protected classes that you should certainly address. Do you have differently abled borrowers portrayed within those marketing images just the same? Trying to take a really hard look with your marketing department to say, okay, were the past 7 images of the quintessential same demographic, or can we diversify to make a stronger impact for our marketing efforts will be key for the CFPB in particular.
I would also add, in terms of images, I would be mindful of what you identify as neutral images, images that may not actually show a person's face. I've heard, so let's say they show a pair of hands. I think the CFPB will go as far as analyzing the hands to make a determination of what type of clientele are you trying to market to, or whether there's diversity. So I don't think images need to only include, a face to demonstrate diversity. So I would be mindful of what I'll call neutral images that don't actually contain a person's image, but other elements.
That's so true. And even I've heard of cases where they're taking a look at the housing size represented in the image. Is it the cute cottage, or are you doing for sure 5-bedroom, 4-bath images on your website? Is that what's on the homepage? Is that what somebody sees, or is there a nice scrolling line of different types of housing opportunities? Because it could be subliminally exclusionary for certain protected classes, always viewing through fair lending lenses, which leads us to the next topic, which is targeted ads and minority markets, right? So some best practices for institutions we did talk about, we kind of bled over from the previous slide, definitely keeping in mind all the different marketing mediums, not just social media, but also those flyers, where they're going to. Are you keeping those addresses on file? Something key to also keep in mind is if you are looking within these compressed margins markets into looking for buying ad lists, where are you buying those lists from? Who's representative on those lead lists, the data that you're purchasing, what's the market that you're essentially buying that data from? And then keeping in mind that technology is ever evolving, so targeted ads are going to be part of that modern day redlining that the DOJ is taking a really hard look at, specifically on social media. So for those who haven't heard yet, in 2019, some time ago, Facebook was in a suit with HUD where there was strong allegations about how Facebook was allowing for the discouragement of housing and credit opportunities based on their targeted ad elections on social media. So you can choose the age demographic and the location demographic. You can even go so far as to choose financially affluent users or non-financially affluent users. So there was a lot of opportunities for a loan officer to get really pinpointed with who they want to market to, and those are the only people that I care about based on the book of business I'm looking for. So as a result of that suit, Facebook made changes to their ad console to try and put some protections into place. So if anyone is familiar with going through that process, as you start to create ads and set those up, you have to, in part, disclose what type of business you are. Are you somebody who is offering something related to housing or a product related to credit? If so, we're going to automatically remove some of those fields. You don't have the opportunity to create a fair lending violation if we take away those fields from you, right? Which sounds fantastic. Until you go through the process yourself, again, always checking out that dog food yourself before unleashing it to the loan officers, there's a really easy way to just turn that off. If you don't want to make the election to say what type of product you're offering, you don't have to. Those fields open back up. So addressing that from a policy standpoint, if you allow targeted ads within your business, what kind of monitoring parameters do you have in place? For that, are you giving your loan officers really clear guidance about what the expectations are for targeted ads if you're allowing them to do so? A lot of lenders, I will say, discourage this practice holistically unless it's done by the lender themselves. It might be a organization specific opportunity only and not a loan officer opportunity. That being said, a lot more states, as we kind of mentioned earlier, talking about state by state, are getting a little bit more social media savvy. So our good friends in New York, for any of you who are licensed in New York, which probably cut down like half of the people here, New York very often can lead the way with compliance expectations. They can set the tone. So we got quite a few lender partners who reached out about a audit in New York that was under Governor Cuomo, where they were requesting login credentials to the Facebook ad suite so that they could see your demographic elections for themselves. So that was quite intrusive. A lot of lenders felt uncomfortable about that. And so keeping in mind that even though the governor may have changed, that states are really starting to get in tune with how social media functions and the opportunities your loan officers have. Can you say to your regulator, we've done all that we can to make sure that the consumer is protected in this regard? That will be essentially key for sure. And then that leads us to one of the final slides. I know we're coming up on time, so we'll see about blazing through it. So LEPs and social media. So LEPs, because we don't have enough acronyms in this business, right, are limited English proficient borrowers. So borrowers who have English potentially as a second language or maybe aren't proficient at all would fall under the header of LEP. A lot of lenders are looking to strengthen their fair lending initiatives, loan officers in particular, by advertising in other languages. So maybe you have a Korean loan officer who has a really great book of business for the Korean market. They want to advertise in a way that's going to be best communicated to that class. With that being said, they'll make advertisements on social media in one way, and it does have a really good, warm feeling to it. You like the idea of consumers being able to understand product opportunities for them in the language they're most comfortable. However, do you go through that process and then when they sit down at the closing table and it's document time, do you support that language for the rest of the length of the transaction is going to be key. This is where it could be a bait and switch situation, a UDAAP violation, where there's a deceptive act or practice at play, where the consumer didn't fully understand all of the consequences that might have come with that financial transaction. So making sure that you as a lender are deciding what languages you do support for the full length of the transaction, making sure that if advertisements are allowed in a certain language, that you have the ability to essentially translate them to see if there are any other compliance concerns at play, because just because it's in another language doesn't mean it's hunky-dory, right? We know that for sure. And then making sure that you're evaluating as you're starting to take steps closer to accommodating LEPs, what other technology might be in the space to help you. I know that the CFPB had issued, I think back in 2021, some advisory content around UDAAP and LEPs and how they understand that there are conflicts that comes to LEP provisions. You only have one note, so how could you possibly have the note in another language and then it comes into play? If I want to file it, does that mean that these classes of people are adversely affected with double filing fees if we're to file two notes? So there's a lot of questions that remain unanswered that we as an industry are trying to tackle. Being mindful of that in your advertisements and how the rest of that transaction looks is going to be important, I think, for the future of the business.
Yeah, I think we could keep talking about this topic for a long time. I'll just add really quickly because I want to leave some time for questions. In California specifically, there is a rule around negotiating in a foreign language and what additional requirements you need to meet if you are negotiating in a foreign language. So, you know, is an advertisement a negotiation? You know, I think it depends on what the language says, and that's something that each business has to look at and decide. And perhaps make clear to the consumer in that language that you don't negotiate in a foreign language, or have the, like you mentioned, the documents available, or at least certain documents to help illustrate from maybe a litigation perspective that they had knowledge of the terms when they entered into that transaction. And then the other thing that I think lenders need to start considering is, you know, does LEP and advertising in a foreign language or communicating in a foreign language, does it stop with the transaction? You know, does it go on to servicing, and how do you achieve that? So I'll
Right.
stop
Really-
there because we're at, yeah, 11:55.
We knew we were gonna have to blaze through some of this. We had a lot that we wanted to cover for sure. So the key considerations for social media, finishing it out is, taking a look at profile compliance, the digital business card. Are you up to snuff? Keeping in mind those compliance enforcement actions, they're not stopping anytime soon. We're seeing a different bulletin come out every day, at least my email inbox is, from the CFPB, keeping up with those, making sure that you're reading through them. Do you have policies to address really specific parts of advertising around targeted ads, modern day redlining, those reputation risks, LEPs and UDAAP? Because we know that the basis of all of this is going to be a really strong policy that's specific and non-generic, and of course having maybe some monitoring programs in place. Well, please go to the next one. And that really sums it up. And I see that Paula's back to host some questions for us.
Yeah, you guys did such a great job. You easily filled up the whole time, and you even had extra time today. So you guys did excellent. Bella, you lived up to your reputation. Thank you.
Thank you.
I know I took away just about 1 to 10 items from each slide that now, thank goodness for job security, right?
Right.
Work on, especially those new platforms. That is very interesting, a lot for us to learn and figure out. Sam, did we have any questions come in already?
We haven't had any questions come in yet, other than compliments to Melissa and Bella on such a great presentation and content. So thank you guys so much for being here today. But if you do have a question for Melissa or Bella, please feel free to pose that in our dialogue box, our Q&A dialogue box. We do have a few minutes left if any of you do have questions. I don't see any that we have right now.
They're just too busy sweating at home about everything we talked about today.
We're just so
We
thorough.
understand.
Very true.
Right.
Melissa is a wealth of knowledge. I wrote down 3 notes during the webinar. So even as a presenter, I'm just like, oh, need to write this down.
Right.
Yeah.
Such great points from everybody. If anybody does have questions that come up, we would certainly recommend reaching out to Bella and myself via email if need be. We hope to work collaboratively in the compliance community where we can, for sure.
Yes, we know our salespeople collaborate, so we also need to collaborate.
Right.
So that we can keep up.
We have more compliments rolling in. We haven't had any other questions.
There's just too much information, and we all have to absorb it. But I'll talk about what's next month. So cybersecurity, which is something we all wish we could just depend on IT for and not have to think about, but unfortunately we do. So it is something we need to worry about also in compliance. Do not wait for the ransom demand to arrive. Have a policy, have a plan, know what states you need to notify if you have a breach. It can happen. No matter how strong you think you are, you never know. You could have an employee click a phishing email and there you are. So definitely have your training in there too. But this is going to be very great next month. Very excited about it. And then also in December, we are already planning and working on our legal issues and compliance conference. It'll be early in December. It'll be in Orange County again. Come and enjoy Orange County, and let's have a glass of wine and talk about Townstone. I mean, that sounds great.
You do need a glass of wine when you're discussing that. So I agree with that comment.
Many glasses, maybe.
Well, thank you everybody for being on the webinar today. These are recorded and they are on the California MBA YouTube. So subscribe because there's plenty of webinars in there and lots of great information, plus on the California MBA website. So thank you everybody and have a wonderful day.
Thank you.
Thanks everyone.
Thanks, guys.